The VA appeals process is undergoing a complete overhaul. Understanding these changes will be important for you to know how best to navigate your claim through this system. In our first video, we gave an overview of the whole system. In the second video, we reviewed the changes that are taking place at the regional office where you file your claim. In this video, we'll look at the new system as it pertains to the Board of Veterans' Appeals. This is the new layout of the VA appeal system. Once an initial decision is reached, the veteran has three options for keeping the claim going. The first option is to file a supplemental claim with new and relevant evidence. The second option is to ask for higher-level review. Lastly, you can file an NOD to go direct to the Board of Veterans' Appeals. Let's start from the beginning, filing a claim. When you file a claim, the VA has a duty to assist you to win your claim. This duty could mean the VA has to get service records, medical records, and Social Security records. Sometimes, the duty to assist includes getting the veteran a C&P exam. The VA's goal is to issue a rating decision within 125 days. Although similar to the way the rating decisions used to be laid out, now it must include the following: identification of the issues decided, summary of evidence considered by the VA, summary of applicable laws, identification of findings favorable to the claimant. The VA is then bound by these favorable findings throughout the adjudication or appeal, absent clear and convincing evidence to the contrary. If denied, identification of elements leading to the denial, explanation of how to obtain or access evidence used in making the decision, and identification of criteria that must be satisfied to grant service connection or the next higher level of compensation. Once an initial decision is issued, a veteran can hire an attorney or agent. It used to be that a veteran had to file an NOD first, but now a veteran can hire an advocate and the advocate can help decide what way to move the case forward. If you disagree with the decision, then you have three choices to move forward. Those options again are file a supplemental claim, higher level review at the RO or NOD to the BVA. The veteran has 1 year to enter his claim into one of these lanes if he wants to continue his case. Having previously discussed the supplemental claim and higher level review in the last video or regional office review, we are going to focus on what your options are if you want to take your case to the Board of Veterans' Appeals. The BVA is the last stop for an appeal in the VA system. To go to the BVA, you file a Notice of Disagreement, aka the NOD, within 1 year of the decision. Before this new system was created, a veteran had to file an NOD, get another decision from the RO, called the Statement of the Case, and then file a subsequent appeal to get to the BVA. Now, the NOD takes you straight to the BVA. There are certain requirements for the NOD. Must be in writing and identify the specific issues with which the veteran disagrees. Note: BVA must review the issues the veteran lists liberally and seek clarification from the veteran when it cannot identify a denied issue before dismissing the appeal. Also, a veteran can request to modify the NOD within the year of the decision or within 30 days of BVA receiving the NOD, whichever is later, unless you have already submitted evidence or testimony. Must be on the VA's specified form. The NOD must be filed directly with the BVA. The veteran can request a hearing before the BVA, submit additional evidence with the NOD, or request a review without a hearing or additional evidence. Let's explain this part of the NOD requirements because this is where some confusion will come in. As there are 3 lanes once an initial decision has been made at the regional office, there are 3 lanes in the new appeal system at the BVA. The first docket is the direct docket. This lane, or docket as BVA calls it, is for veterans not asking for a hearing or the ability to submit new evidence. The decisions in this docket are supposed to be decided the fastest. The VA is on record saying that these cases should be decided within an average of 365 days. The next docket is the evidence-only docket. In this lane, BVA will consider new evidence submitted with the NOD, or within 90 days of filing the NOD, or within 90 days of moving your claim out of one of the other two lanes and into this one. The third docket is the hearing docket. BVA will consider evidence in this lane up to 90 days before the hearing. There will be two types of hearings: in person in Washington, D.C., or by video. There will no longer be travel board hearings where the veteran goes to his local regional office and meets in person with a BVA judge there. A veteran can ask for a change of date of the hearing or a reschedule if the veteran misses the hearing. However, she must have good cause to do so. BVA Order of Consideration. BVA will prioritize its review of claims in this order: first, direct docket, then evidence docket, and finally, hearing docket. BVA is trying to incentivize veterans to not go into the hearing lane. An appeal can be moved from one BVA lane to another only when the NOD is modified. Moving a case will not change the effective date. BVA remands must have a new NOD. In the old system, BVA could remand or send back cases to the RO for no apparent reason at all. This could add years to a veteran's claim. Now, it can only remand to correction of an error where the VA failed to properly help the veteran win his claim. These remands are supposed to be expedited by the RO. The VA does not say what expedited means. In the old system, when the BVA remanded the case and the RO denied it, then it is automatically sent back to the BVA without any required appeal from the veteran. One of the most important changes in this system is that the BVA will not automatically review a remanded claim if it is denied by the RO when it is sent back. Now, the veteran must file a new NOD to go back to the BVA. Why is this so important? In the old system, up to 90% of remanded cases were denied by the RO and sent back to the BVA. Now, those claims denied by the RO will not go back to the BVA without a subsequent appeal from the veteran. BVA decisions. Lastly, it is important to understand how this new program protects the effective date of a potential award. The effective date is the date from which the VA will pay benefits. Usually, it is the date of the last reopened claim. With the new system, as long as you choose one of the three lanes within a year, then your effective date of any claim granted should be the date of the claim you filed at the beginning. Also, if the BVA denies your claim, then you can reopen with a supplemental claim with new and relevant evidence within 1 year of the decision. If you subsequently win, then your effective date will be the one filed at the beginning. Alternatively, within 120 days of the BVA denial, you can appeal to the Court of Appeals of Veterans Claims. If the veteran loses at the CAVC, then they can reopen with a supplemental claim at the RO with new and relevant evidence and keep the original effective date.